But I would like to place before your lordships the government's perspective, why the architecture of the MMDR Act is the way it is and how it impacts the power of the state versus power of the center. But before I do that, I want to make one thing very, very clear. Because the impression, which is unintentionally gathered is this, that this is kind of a federal issue between center and the state, and who has the legislative competence to levy. At the outset, I say that is not the question here. But here, and as I will explain in a little more detail with some facts, figures, and statistics. The way MMDRA works, and it is intended to work as a limitation, is this one. It is not a fact in dispute that the mineral rights and the ownership of mineral waste with the states, and therefore every penny of royalty goes to the state government. If your lordship would not like to write down, I have the propositions also. At the end, I can give the propositions.
Yes.
But just to make it more convenient for your lordships. Every penny goes. The state government grants the lease. The lease deed format is provided in the central statute.
Yes.
The state government collects the royalty. The royalty figure is fixed by the central government. The state government appropriates that royalty amount with other amounts which I will show as a part of its consolidated fund. So these are not the facts which are in dispute or which can be in dispute.
Yes.
Now, my lord, why the center discharges the function of only fixing the rate of royalty qua each mineral? There are several factors, my lord, which I will show, but broadly, to ensure uniformity in the price structure throughout the country.
Yes.
And my lord, our domestic price structure will have to take into consideration two factors. I'm just giving a broad overview. One, the domestic requirement, which can only be decided at the central level. And second, since the royalty has a direct nexus with the price of each mineral, we will have to be very, very careful and conscious about the global market qua that mineral. If that mineral is cheaper somewhere else, people would start importing, Indian domestic users, and vice versa. So it directly impacts the import-export. I'll not go into the details. But next and the most important thing, but as I would show, my lord, from one report, which is prepared, my lord, every 3 years. Your lordships are aware, Section 9 provides that the royalty will, the rates of royalty would be changed every 3 years. So, my lord, there is a report prepared. My lord, it was really heartening to know.
Yes.
A classic example of cooperative and collaborative federalism. What the central government does, your lordship did not write, in my note, your lordship would find everything. We call for the views from all stakeholders. Stakeholders would mean industries, stakeholder would mean people who are going to be affected by the industries, because ultimately we have to protect the environment as well, and essentially and more importantly, the state governments. I'll show, my lord, from the last report of 2019 that the state very effectively involved in the process. They say that this particular mineral, bauxite, please increase it by 2% because this is our revenue generation. These are the reasons why it should be something more. Then the subgroup, after receiving all these detailed inputs, examines what are the global scenario, what will be the impact on the export-import. But all these minerals are required for the core industrial sector of the domestic market. That is taken into consideration. The core industrial sector is the heartbeat of any economy. So that is considered, and I will show that to your lordships. And thereafter, with reasons why the state's request is either accepted or not accepted, my lord, a price is fixed qua each mineral, and thereafter the central government is out of it. Now you collect, you appropriate, you do whatever welfare activities you want to do in your state. The only dispute between the parties, my lord, in these proceedings is, after having, my lord, it is our case that when we decide the amount of royalty, the figure of royalty, that is all inclusive, taking into consideration all your requirements. What the states say, that over and above the royalty, we can independently levy certain amount under various names. What we believe and what, my lord, the Act perceives, the objective of the Act is that, and my lord, whatever I am saying, my lord, I will be able to make good from, my lord, the record. So suppose iron ore or bauxite, some amount is fixed, say 100 rupee per ton or per whatever, my lord, there are, my lord, pit's mouth value, etc. That also was argued, but I'll show that's not relevant for this purpose. So the amount comes to say 1,000 per ton, giving a absolutely hypothetical example. They say that every state will have a power to levy something more than 1,000. We say no, it is all inclusive, and the reason is this: if every state start imposing further levy, in some case it would be 1,500 per ton. In some case, it would be only 1,000 per ton. In some state, it would be 1,100 per ton. The uniformity of the prices will not be maintained. And I want to flag, my lord, that issue before, my lord, I take your lordships to this, my lord.
Mr. Solicitor, as you are formulating your thoughts, and you have given the example of bauxite, and you say that this rate that is determined, and you said that this is done after elaborate consultation with the stakeholders, including state. And then you say the state is trying to extract over and above the all-inclusive price which you are suggesting to us.
Correct.
Now, taking a cue from the example of bauxite, have you not boxed in the state so far as exercise of their power under 50, entry 50 list 2?
I could not understand the last.
You see, I have said that we have boxed in everything. So where does the state have the power to exercise under entry 50, their power of tax?
That's my lord, respectful submission that the entire architecture of MMRDA, under which this box price inclusive of everything is fixed, is a limitation on the state's legislative power under 50.
But it's totally denuded, you see.
That's my respectful submission.
No, correct.
But otherwise, I'll just give an example, my lord, my lord, why this creates a problem.
Why should the, I mean, just asking, of course, you are just on the starting point.
Yes, my lord.
Why should the act, the statute, not say that this is what the tax that the union is charging, and to this extent the power is denuded or something to that effect? Why are we asked to read this by inference?
My legal submission would be different.
We also have the situation of, I was just discussing Article 265.
I am merely fixing the role.
That's one which will be forthcoming.
It is there. It is there, my lord. It's invalid text, my lord. It would be unconstitutional. But I'll be able to show that there is an inbuilt statutory mechanism which says that this amount and nothing more. Otherwise, my lord, what happens? Just give, of course, example would not, my lord, be the basis for your lordships to decide. But I'm just giving an example, the rationale, why, my lord, this is under the central control, the fixation. Lord, suppose there are two states, A and B. A has, my lord, an electricity generation station of a huge capacity. They are using coal as a raw material. B has raw material mines, my lord, namely the coal mines. They say that over and above 1,000 rupee, which is the royalty fixed by the central government, my lord, I'll give examples. In many states, India segments, other SAS, education SAS, different nomenclature, was 300% royalty, 500% royalty, etc., etc. So that state A having the electricity generation plant will have to either pay more from state B, because every state has a different price structures.
But Mr. Solicitor, that is implicit in a federal scheme. You see, therefore, unless you say that, look, when you fix, as you call it, an all-inclusive royalty, that royalty includes all taxes also that can be levied by the state. You have to go as far as to establish that.
Correct, Manoj.
That the fixation of royalty is itself inclusive of all taxes, state
And nothing more.
That's one. Second, your argument that, well, it's desirable that there should be uniformity of the price of minerals. It may be a desirable matter as a matter of policy. Question is whether this will impinge upon the federal distribution of power under the Constitution. Now take another case. Look at, there are several taxes the states can levy under the state list.
My lords.
I'll just give you two examples. Entry 53 of list 2, taxes on the consumption or sale of electricity. Right? Now, in various industries, electricity is not just a medium, but it's a raw material. For instance, in the production of steel, iron and steel industry, electricity itself is a raw material.
Yeah.
It's
part of the price structure also.
Right. And now the Constitution contemplates that each individual state can levy a tax on the consumption and sale of electricity. Now, different states levying taxes at a different rate on the consumption and sale of electricity will meet with the same argument that you are urging, that in Maharashtra may impose it at a different rate, Karnataka may do it at a different rate, a solar plant in Rajasthan may do it at a different rate. But that's part of the federal scheme. Or take entry 54,
Right.
taxes on sale of petroleum crude, high-speed diesel. High-speed diesel is crucial for industry. Motor spirit, natural gas. So if you are consuming natural gas from, say, which comes in from Jamnagar, different rate altogether. If you are importing natural gas, which has come in through, say, a crude pipeline, a gas pipeline, say, in Chennai, completely different rate. That's exactly the scheme of the Constitution. That and there is nothing sui generis about minerals, that there should be a uniformity. Then the same logic will apply to electricity. Have the same rate of electricity, same taxes for electricity.
Ignore that example and I'll give the answer. In other entries like electricity or entry 54 list 2, there is no provision like entry 50 that's subject to limitations placed by the Parliament under 54.